This is take 3 because this is me trying to parse a law. I'm going to read it, try to get through it, because it'll take less time when I screw up, not if. I've done what's called, well, let's just read this. I'm going to read the cleaned up version of it so you don't have to put up with this. The local government cannot require a wireless company to hold the local government immune in case of a legal claim. The local government cannot require, in any way, shape, or form, even if they already signed a contract, they cannot require that the wireless company be able to be forbidden from suing the local government for whatever happens, and they can't require that everything the wireless company does makes the local government immune from prosecution in a court case. What this means is if the local government makes a contract with a wireless provider, it cannot include a rule that says the wireless provider has to take all the blame. It doesn't mean that the wireless provider is immune from prosecution. It just means that they can't make it to where the local government's immune. The only time this happens, and it's obvious, but it has to be stated overtly, is if a court has found negligence only with a wireless provider, then it can require that the wireless provider cannot hold the local government, can't do a frivolous lawsuit. This is a protection that indemnifies the local government from the wireless provider, in effect. Even though it says they're not allowed to require it, this has the effect of causing it. It means you have to be on equal footing. Whoever is guilty of causing it is the one guilty of causing it, and the only time anyone is excluded from frivolously suing someone is when it's already been decided they were solely responsible. If the wireless company is solely responsible for a cell phone antenna hitting your house, they can't try to pass it on to the local government if they're responsible in court. A local government cannot make a rule requiring a wireless provider to provide insurance that names the local government as an additional insured person against anything at all. They can't create an insurance. The local government cannot require the wireless provider to require a wireless provider to obtain insurance naming part of the government. Or does it say the exact opposite? Now you can read the original wording of it, and it makes it as ambiguous as is physically possible. So we'll just ask this. Should the local government require a wireless provider to provide insurance just in case the city is guilty? Okay, this is what it's addressing. What it actually says, I'm trying to interpret. It's like the other one. Should a local government be allowed to make a rule making wireless companies exclude them from lawsuits all the time? Okay, next, we go on to the next. Local governments are generally prohibited from altering zoning ordinances with provisions that require someone to pay something to a third-party vendor contracted by the local government to assist with any kind of process in general. It's an acknowledgement. It doesn't make a rule. It just acknowledges this. In general, the local government is prohibited from altering zoning ordinances to induce costs that you have to pay some third party. So this is acknowledged. Next one. Existing local government rules that contain a provision requiring payments to a third party shall be modified to remove this provision within the next few days. This is not making it to where you can't sue the wireless company, and it is not making it to where you can't sue the city. Most of this is just restating what you and I would consider common fair practices in fair dealing when dealing with a wireless company if you were contracting them to do something. Let's say you were going to do a concert in the area and you wanted Cellular 12 up the street here to set up a Wi-Fi hotspot in the middle of the concert so you don't have to drag down the local, AT&T Wi-Fi hookup. You might have a bunch of rules that say since they're putting up a tower, they're responsible for the tower and you're not. But if you cause the problem, you are. I know this is obvious stuff, but this makes it to where you cannot legally get away with filing a court case to delay things or whatever and get away with something. MGM should not be allowed to make it to where if they make a concert, that nobody can sue them because they're not on the grounds that they control when it's obviously their concert. See how this works? Liability laws are also based on frivolous lawsuits based on liability. A lot of these provisions are in place to say you can't sue the city of Portland or you can't sue Chicago for any reason. Is that fair or not? And are frivolous lawsuits really destroying America? This is where this is all coming in. So if someone says this is indemnifying so that you can't sue a wireless company, this is only between the local government and the wireless company and a few other things going on here. So let's go on to the next stage and see what happens. Any third-party vendor the local government contracts with to assist in making new ordinances or modifying existing ones, changing any local laws, that violates any of the provisions so far will have to pay $10,000 for the violation. Meaning any third party, not the local government and not the wireless provider, any third party that might be a middleman is subject to a $10,000 fine at minimum per incident if they break any of these rules. Because somebody might set up a third party vendor to try to get around these rules. Trying to avoid the rules means you get a fine. I would make it $100,000 because this is big money they're talking about. House Bill number 1620, 2017, amending the Act of 2012, October 24th. That's what this is. Known as the Wireless Broadband Collection Act. Is that a real good name for what we just talked about? This is mostly this part here is just about the liability and indemnification rules that people stick in contracts, making it legally impossible, even if you sign a contract, for it to be enforced within the state in this very narrow range at all. Meaning if you sign on with a broadband company in the area and they make a rule that violates this, it's not enforceable. It protects you and me, including me not being in the state, because this is a different state. If I go to that state, this law is in force. Wireless provider in Portland, Oregon is not required to follow the Freedom of Internet Act, aka net neutrality rules, because assholes in my federal government removed it. The state of Oregon made a set of rules. If you are involved in any way, shape, or form in telecommunications, period, full stop, anything, and you do anything that harms consumers, in a very vague way, they say, we are going to invalidate all your contracts if we feel like it. Why? So that they would never make a rule that says, if you don't get broadband for a month, you still have to pay for it. Who shot it down? A bunch of interested parties that happened to be Republican one year and Democrat the next year, who all had money invested in local telecom companies. They removed our not net neutrality rules, but our fairness laws. What other vendor do you know of that provides a service that doesn't legally have to provide the service and can still demand money? Insurance companies? Insurance companies are defined by the idea that the only service they provide is later on. You're paying for future service. What if an insurance company decides they won't pay out? That's a violation of the contract. No, it isn't. They get to decide whether or not it's valid. No, many states say that an insurance company has to default to pay out unless they can show a compelling reason not to pay out. But that's government regulations and revenuers, and they're ruining the insurance company. Oh, wait a minute. This would drive down the costs of medical costs and force insurance companies to pay for your freaking leg when it got broken, right? Regulations aren't always evil. Regulations are now normally written in quasi-ordinary English. And as you can see, this is the best I could clean this up. So I'm going to waste the next 5 minutes of your life here because I'm going to review it. This is supposed to be called the Wireless Broadband Collection Act, and it has a bunch of other pieces to the name. They're search engine strings, so you can find it. This is like the tags and meta tags in your YouTube video. They don't mean what you think they mean. On page 22, section 6.3, it had this to say, and I'm going to review this one more time. And again, this is supposed to be the Broadband Collection Act, and these are the legal provisions that are supposed to stop frivolous lawsuits and delays, and also enact a $10,000 fine if you try to get around it. Your local government is not allowed to require a wireless company to hold the local government to be immune from prosecution or court cases concerning activities unless the wireless company is exclusively at fault. This makes complete sense. Obviously, if the wireless company is guilty of doing something stupid like dropping an antenna on your house, the local government shouldn't pay for that. Even if they were installing it on a hunk of dirt that the city government let them use, they're not at fault because they didn't drop a house on your witch mama. So yeah, we're going to invoke anti-am. So anyway, next, the local government cannot require a wireless provider to provide or obtain insurance, naming any part of the local government as an additional insurance. The city and the wireless company have to have their own insurance company deals. They could combine them, I guess, but this makes it to where it can't be a requirement. It can be an agreement. And if they do sign a contract that says this, it is subject to arbitration, because this law makes it to where from this point forward, and maybe retroactively, they could add that in later, that if you sign a contract that violates this rule, you can't enforce that piece of it. This is like a kid cannot enter into a contract. If they do, you can't enforce it because it's a freaking kid. So no, I don't have to pay back the album of the month club. I was 16 when I signed that paper. Anyway, let's get on with it. In general, local governments are prohibited from changing zoning so that it would require people pay extra money for all sorts of stuff. Existing local government ordinance that contain provisions requiring rate changes, blah, 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 will actually change. They can't rig it to where somebody putting an antenna next door costs you money or costs them money. They have to do this on an individual basis. Any third party, even ones contracted by the government, to assist with doing any of the modifications or work of any kind that tries to break any of these rules has to pay a $10,000 fine. None of this, quote-unquote, makes a wireless company immune from hitting you with ray beams from 5G. Now, you can decide easily to interpret it that way from the horrible, almost it's totally impossible. I can't even. But when you tear it apart, especially when you stop letting it repeat things like fees, fines, faux fum, blah, blah, blah. If you actually take it out and just say any financial or any legal claim, if you simplify it down, this really does make it easy to understand. This is my third take. I've revised this thing 8 times. This is why lawyers get paid more money. And this is also a problem. Would it be better if it was Latin or Esperanto? Would it be better if they did subheading provision like you do in the federal government? They're attempting to make this readable for ordinary people because many states also passed a law that says any law that is not understandable, any law that isn't readable at all, just the starting point, readable, grammatically correct for people within that state that are considered the majority of the population. That actually is part of the revisions. If the majority of people in California are from Mexico or primarily Spanish speakers, it has to be understandable in Latin, literally, because it's a Romance language, or whatever. If you're in France, it has to be understandable by French people. So many states have laws that say if you make a law like this that affects anybody, if it only affected the wireless company and didn't affect you and me, they wouldn't care. If it affects the people, by and for the people, they have to be able to at least read it. It has to be in the language they use. It has to be grammatically possible to understand it. It doesn't have to be easy. It just has to be a little easier to do. And it's nobody's fault out there for misinterpreting this. Even me, I could have obviously misinterpreted this. That's why the link below says trackbill.com, and it goes on and on and on and on and on and on. Because yes, the title of this, really? Suddenly the Dewey Decimal System looks easy. Yes, that below, that link from hell, is literally the entire goddamn title. That's why I didn't read it. No, it doesn't make it to where wireless companies are not responsible for anything negative happening to you at all. That was a misinterpretation, and it's totally obvious that anybody would make that interpretation. And yeah, it is kind of their fault doing a bad job of this. Now, this has gone through enough revisions that there may be parts in it changed later. But that was 2017. Thanks for watching. Have a good day. Good luck with that.